If we could at least have the substantive.
Yes. Well, I just designated a vet with authority to get into my dashboard to help me since my JA is gone and my former JA, who was going to come back and help me, has gotten a really bad health diagnosis, so she could not come back today. Off the record. And she's got cancer in the brain now.
All right, let's bring back in. Franz, let me start with you. First of all, interesting, the jury instructions. That gave us some good insight. The state asked, we want first and second degree instructions with self-defense for the second. And then the defense said, we want the accident instruction. Does this tell you anything about the direction this judge is going to give the jury?
So all trial long, a lot of us have said, this seems like a self-defense case, but then they raise the accident, and those aren't mutually exclusive. You can have a self-defense that happens with an accident. So I think, no pun intended, I think it's going to be a shotgun approach by the defense that culminates in a, this is self-defense, but by the way, it was self-defense that happened as a result of an accidental discharge based on the behavior of the victim. I think that's going to be their approach. And they've got the instructions now. So, I mean, it seems like they're going to be able to argue that.
And I did hear that the defense had an objection, but I wasn't sure what they were saying they objected to. Jenny, what are your thoughts about these kind of instructions? Because it feels weird to say he got the gun in self-defense, but then he shot him accidentally. But all along, I think that's the direction this defense has been going.
I agree. And I think that one thing that the prosecution is going to try to say is, okay, they're going to focus on the fact that he got a gun, he decided to get a gun, and it's not reasonable that that would de-escalate any situation. But I think that Franz is exactly right, that the defense can argue, well, it was self-defense and the shot was actually the accident. And all the defense has to do is create reasonable doubt in one of these jurors, and they may be able to do it based off what I've seen in this case.
And the one thing that I always hang my hat on is the fact that the gun was up to or on or very close to the victim. And to me, if somebody's going to deliberately shoot someone, they don't put the gun right on them. They hold it back from them a little bit. So for me, in my mind, that would be a fact that I hang my hat on. Let's listen together, and then I want to talk about it more, to a mash that Court TV has made of the defendant testifying on cross-examination, and then talk about that.
When you chased him with a taser and a shotgun, and you were approaching him, according to the video evidence, he never approached you, you approached him. Why were you approaching him?
When I approached him with the taser because I wanted to stop and neutralize the threat.
Weren't you taught de-escalation tactics?
Yes.
Did you use any of them?
Yeah, I tried to.
Which ones did you use? While holding a shotgun?
I tried to remain calm, or remaining calm can be de-escalating.
Okay. What else?
Tried to keep some distance.
But you were going after Riley.
With the taser, yes.
How is that keeping your distance?
Well, there's two different things. At some points, I was trying to keep my distance. At that point, I tried to get close to him with the taser because I thought if I could use the taser, the stun gun, to stop the threat.
What threat?
He was running down the road before the video starts, yelling, "I'm gonna get you."
Did you ever tell Deputy Thorpe it was an accident?
No.
Did you ever tell Officer Shabilsky it was an accident?
I don't think I told anybody. I kept my right to remain silent.
Trial attorney Jenny Brown, you know, that is not the way that trial skills is taught to do cross-examination. When you ask a question, you don't want it to be an open-ended question on cross, but rather one that's leading that you get the jury to hear what you're saying. It doesn't really matter what the answer is. However, giving the defendant the ability as an open-ended question to explain it, to describe it, do you think he helped himself at all on the cross-examination?
I think on cross-examination overall, he did pretty well. He kept his answers short and answered exactly what he was asked and didn't necessarily expand on them. He let his attorney be the one to answer any particular questions that may need to be expanded upon. And unfortunately, a lot of defendants, when they're on the stand, they don't have the ability to stop talking. And he overall did a pretty good job there.
All right, Franz, I want to circle back to something you said, and you thought you're kind of leaning with the defense and maybe reasonable doubt. What specifically stood out to you, if anything, to say, oop, that could be reasonable doubt for this jury?
I like the fact that there is discussion, testimony about calling the police. I like the fact that he came across as credible. I thought he was credible when he testified. He may not have been. That was just my knee jerk. I think the state's key witness was horrible. She was supposed to be the make-all witness. She was terrible. And I think the poor presentation, poor prosecution gave the defense enough wiggle room to say, this really was an accident. They created a story. What's the story for the prosecutor? I'm still left with a loss for what's the story for the prosecution. So for me, I have a story with the defense. I have at least a doubt. Doesn't mean that he didn't commit murder. I just have a doubt. And if I have a doubt, then maybe they have a doubt.
Yeah, that's a great point. Jenny, just quickly before we go to break, his demeanor is one that a lot of people on social media are talking about. We've been talking about here in studio because he is sometimes laughing. He is sometimes oddly reacting, chewing on his finger while he's answering a question, a couple of tears. Did the demeanor make a difference for you in weighing the credibility of his testimony?
Possibly. I think people act differently under stress. And yesterday was his first day on the stand, and he was emotional, at times crying. Today, he seemed much more pulled together. A lot of that just might have been how much emotion he had worked up getting ready to take the stand. But it could possibly be a factor with the jury.
All right, Franz, weigh in on the demeanor of the defendant. Any thoughts?
I think that can be addressed by the defense in closing. Hopefully they talked about it in jury selection. And I think that it's all about the nonchalantness of this individual, whether it's a quirk, whether it's who he is. I think the defense can look at the jury and say, they made a big deal about how he was nonchalant. At this time, this is who this guy is. Like it or not, this is who he is, and this is consistent with how he behaved in the courtroom. He was being truthful.
And I think they have to own it. Are
Yeah.
they going to? We'll have to wait for those closing arguments. Jenny, Franz, you're going to stay with us. Thank you. Coming up next, we're in Verdict Watch in the teen escort murder trial. You can see it up on your screen. 1 hour, 22 minutes right now of deliberations. Joel Hollendorfer is accused of killing an escort during sex. We're going to catch you up on the biggest moments of that case as we wait for the jury's decision. I did hear that the defense had an objection, but I wasn't sure what they were saying they objected to. Jenny, what are your thoughts about these kind of instructions? Because it feels weird to say he got the gun in self-defense, but then he shot him accidentally. But all along, I think that's the direction this defense has been going.
I agree. And I think that one thing that the prosecution is going to try to say is, okay, they're going to focus on the fact that he got a gun, he decided to get a gun, and it's not reasonable that would de-escalate any situation. But I think that Franz is exactly right, that the defense can argue, well, it was self-defense and the shot was actually the accident. And all the defense has to do is create reasonable doubt in one of these jurors, and they may be able to do it based off what I've seen in this case.
And the one thing that I always hang my hat on is the fact that the gun was up to or on or very close to the victim.